We're going to start off the middle part of our section with Brian Lamb, who's a partner with Thompson Hine in their business and ERISA litigation practice in Cleveland. He heads the firm's securities and shareholder litigation group and is a former member of the firm's executive committee. Being a member of my firm's executive committee, I feel for Brian because I know it's a job you give to people you don't like. He's active with the non-for-profit group called Towards Employment that assists low-income individuals in finding and keeping quality jobs. A substantial portion of Brian's practice involves securities and fiduciary duty litigation on behalf of public companies and corporate directors and officers, as well as the defense of class actions. Brian will be speaking to us on budgeting for litigation. Please welcome Brian.
Speaking of long-suffering sports fans, I'm from Cleveland. In fact, I grew up in Cleveland, and then I came here to New York City to go to law school, and then I went home to Cleveland to practice law. So I know what you're thinking. This guy is like the LeBron James of the legal profession. But it's not true. LeBron doesn't know the first thing about budgeting for litigation. So I shouldn't have to spend too long making the case for litigation budgeting, but I would like to just lay the parameters so we all have the same baseline. BTI Consulting in Boston does surveys every year of in-house counsel and what is important to them, what is the highest priorities they have in their legal departments. In 2002 to 2005, BTI reported that corporations had the same number one and number two most important values of what they were looking for from law firms. One, provide exceptional service, and two, mitigate risk. Fast forward to 2013, 2014, and BTI reports that corporate counsel have two different top values, things they are looking for from their law firms. Number one, deliver more value, and number two, control legal costs. So this is the new normal that you've heard a lot about. You may ask yourself, where is provide exceptional service? Certainly many of the lawyers in the room pride themselves on providing exceptional service. I would suggest that it's assumed that all outside lawyers will provide exceptional service. And now the challenge is to find ways to deliver more value and to control legal costs. So what tools do outside lawyers and trial lawyers have in their toolbox to serve these needs of in-house counsel? Legal project management, process improvement, particularly on recurring matters, alternative fee arrangements or value billing, alternative staffing models, who's going to work on the case, the right lawyer at the right price, and litigation budgeting. And this may be a controversial statement, but I believe it is very true, a very true description of today's legal practice, that a sound budget may be the most important document a trial lawyer will create in the life of a case. And that's a kind of controversial proposition. Some lawyers wrinkle their nose at that and say that's not true. By the way, number two is a New Yorker cartoon, a good New Yorker cartoon. The number two most important document. But number one is, in my view, a sound legal budget. What is this case going to cost as far as you think right now at the outset of the matter? You know, I couldn't have said this with a straight face 20 years ago. I mean, people would say it's a motion to dismiss, or it's a motion for summary judgment, or a nasty Rule 11 letter. Something like that would be what trial lawyers would say is the most important document in a case. But what we are seeing more and more is in-house counsel craves more certainty, craves more cost control at the beginning of a case. And where they're not agitating for budgets at the outset of a case, trial lawyers should be volunteering those budgets at the outset of a case. And I would submit that to trial lawyers, we should look at litigation budgeting as an opportunity, not a burden. It's an opportunity to respond to client needs, and we just saw that the client's top needs are controlling legal costs and delivering more value. So let's respond to that, provide a good, sound legal budget. Show your commitment to the client by agreeing to share risk, and that's what a budget is. You're committing to something in writing. You may not promise or guarantee that it's going to happen this way, but you are putting yourself out there. You are saying at the beginning of a case, this is what I currently expect in my best judgment right now. It's an opportunity to collaborate with clients on their expectations, because a good budget doesn't just have dollars in it, it also has a work plan. What work do I think is going to need to be done on this case going forward? And it's a way to avoid surprises. The client says, you're going to file a motion to dismiss and a motion for judgment on the pleadings. Better to have that discussion at the front end rather than after they see that that's the work that was done in a bill. Our first president once commented that we must consult our means rather than our wishes. This is very instructive for trial lawyers today. I'm no historian, but I suspect he was commenting on the cost overruns in the Marbury versus Madison litigation. But, it's 230 some years later, and trial lawyers are still trying to figure out how to talk to their clients about what this case is going to cost and what our expectations are. So it's really a challenge for trial lawyers who love to right away say, oh, it's so unpredictable. Oh, the other side, they're making life hard. Oh, the judge is making this more expensive than it should be. But think of all the experience we have in this room, all the litigation matters, all the trials, and we have to come up with a better way of estimating what we think something's going to cost at the outset. So the challenge, as I view it, is to build a culture of creating, sharing, and reporting against a budget despite the uncertainties of litigation. So that's the challenge. The best solution that I've been able to come up with so far is to focus on a few key things. One is to standardize and simplify the budgeting process. Lawyers were not trained in how to create legal budgets in law school, that's for sure. So how can we bring some expertise to bear and standardize and simplify the budgeting process? Number two is to give trial lawyers the right technology and data, something that we're getting better and better at. Number three is to take advantage of prior efforts and prior results, all the experience you have at your firm, all the experience the in-house counsel have in their jobs, and then demonstrate and commit inside and outside, demonstrate commitment inside and outside your firm or your in-house legal department if you're in-house, is make a budget part of the process rather than a punishment that you insist your outside lawyers have to have. It's productive for everybody to work on a budget and work plan at the beginning of a case. So what we've created at my firm, there's lots of ways to do it. You can go to the store and buy software in a box. You can use pencil and paper and put on your eye shades and come up with your own budget. You can work with Excel spreadsheets. You can do it with a crayon and construction paper. There's not that many variables in creating a budget. What we've done is we've come up with our own software that we created with trial lawyers and our IT department, and it has these primary aspects. One, it has a user-friendly interface. We're trying to build a culture here, so we're trying to make it easy for trial lawyers to get on board with doing budgeting. It looks like the way we do all of our web-based applications at my firm. We fill out glory memos that we submit each year about how great we are and how we should make more money. We use a web-based application. Well, this software that we've created looks just like that, so that the lawyers feel more comfortable using it. It's our way of doing it. Tool integrity is important. When I used to do budgets using Excel, I was always paranoid that I was deleting a formula or a hidden column wasn't picking up something, and I really sweated the details of whether the ultimate output was correct. This way, with a web-based application, the formula is baked into the software, and the lawyer, it's kind of dummy-proof for us trial lawyers who are making budgets. You put your input in, and the output has integrity. It has connectivity in the sense that it is tied directly to our firm's financial data servers, so you can pull down a lawyer's current billing rate. You can access prior budgets and prior bills to clients. It has ubiquity. What we've done is we've rolled it now out, this app, to every trial lawyer in our law firm has this app sitting on their desktop or their laptop. And we are now in the process of tweaking it so that it's suitable for corporate lawyers, real estate lawyers, tax lawyers, and transactional lawyers. The key here is that we're using the ABA litigation codes, which don't translate necessarily to other practice groups, but we started with pushing it out to every trial lawyer in the firm. It's data-driven. It leverages other budgets that you've created within your firm, and that helps ease the burden on lawyers as they sit down for the first time to say, how much is this case going to cost? So the key elements of our budget app, number one is, and the very first thing we do is answer a series of questions that are the key assumptions of the case. It's not who's going to work on the case. It's what are the key assumptions about this matter. And you could all come up with a similar list like we have come up with at our firm. Are there going to be counterclaims? Will there be third-party practice? Will there be multi-jurisdictional cases? Will you be filing a motion to dismiss? How many days do you think trial will be? How many experts do you think you're going to need? Who's going to be responsible for electronic discovery? There's a series of prompts. It's just kind of like TurboTax or tax cut. The trial lawyer sits at his or her desk and answers these questions, and then there's always a space at the end to type in their own custom assumptions, because no software or group project can ever come up with everything. So there's always a place they can type in their own assumptions. And then after they've listed out what their assumptions are, they assign a level of risk to those assumptions. Is this a high-risk assumption, a moderate risk assumption, or a low-risk assumption? That, when you then provide that list to the client, they can see, okay, you're assuming X, but you're also flagging for me if X doesn't work out to be the case, this is something we really need to keep an eye on. So the major assumptions is always the first thing that we do, and we've set up the software so that that's the first thing it takes the trial lawyer through. Next, you turn to your resources. Who's going to work on the case? How many partners? How many associates? Are you going to use staff attorneys, contract attorneys? Who are they going to be? This software will allow you to either plug in a name of a particular person. You know that Sally Smith is going to work on this case. Or you can say junior associate 1, partner 2, and plug in a title, because in some cases you may not know the answers to those cases early on. We're trying to reduce excuses for why people delay and procrastinate on doing their litigation budgets. Third, and really the heart of the whole app, is the anticipated work. What are you going to do on this case? This follows the ABA litigation codes. I'm going to show you a sample. Right from the beginning of the initial case assessment all the way through appeal. And the ABA litigation section has codes, and we have taken those codes, and then we've come up with our own individual lists of any particular task that might be done to accomplish that work. But this is the heart of the budget. Who's going to do the work, and how long do you think it's going to take? We use a high-low estimate scheme. Sally's going to spend between 5 and 8 hours on this motion to dismiss. The partner's going to spend 1 hour to 2 hours. And then the software calculates how much that just cost you to put that estimate of work into the system. It has a third dimension because it allows you to budget for time. You can say for each task that you are putting in the system, what do I think the anticipated start date is, and what do I think the anticipated end date is? Not for the whole litigation, but for each task. When will the discovery phase begin? When will it end? And then you can budget for that, and as long as people are entering their time in the system using the same ABA codes, which we require, then you can track how you're doing, not just in terms of absolute dollars, but how you're doing in terms of time, and I'm going to show you a couple examples. We've insisted on a peer review process, so I finish my budget, and I need to get approval. I give it to my partner, Tony White, or someone else, an experienced trial lawyer, who will look at it and say, why do you only have one expert? Why are you, this seems light on electronic discovery, and you draw upon the expertise of your colleagues in your practice group. And lastly, I'm going to show you some examples. It generates reports, all kinds of reports. So the first kind of reports are budget-only reports because they just show what you've budgeted. They don't actually have any, they have no tie to the real world. This isn't what you actually bill later on. These are the reports that show you, I've now created my budget. Here's what the reports look like. So this is like a snapshot of a portion of a budget for one case. I can zoom in a little bit. You can see L100 is the ABA code for case assessment, development, and administration. L110 is the ABA code for the more granular work, fact investigation or development. And then we have come up with the stuff in white, all other fact investigation. And for most of these, we have a list of 10 to 15 things a lawyer might do under this area. And you're expected to either say, yes, we're going to do some work on that and plug in hours, or you can hide it. We're not going to do any of that work, and it just goes away. It doesn't appear in your report. You go through this for all of the ABA codes, all the way through appeal, or as far as you want. And then you create, this is our executive summary, which is a little busy, so we can get reports that actually zoom in a little bit. You can see the ABA codes there, the phases, L100, case assessment, all the way through L500, appeal. And this is a nice summary that shows you how many hours you have projected in this budget, and it calculates the fee estimate then at both a high range, a high end, a low end, and a midpoint that you give to the client. So this is the executive summary. You also give them the previous report, which is much longer, which is the granular detail, what work's going to be done, who's going to do it, and what does it add up to. The executive summary also has reports like this, which show you which phase, ABA phase, your budget is assigning the most anticipated costs to. So in this case, discovery is going to be what you're showing the client, the most expensive part of the case. And the client may want to work with you then to say, well, what can we do to reduce the amount of discovery in this case? So it leads to discussion. This one uses the time periods that you entered by showing you how much you're anticipating to spend if this budget were to come to pass by month. You can do it by quarter. We frequently do it more by quarter than by month. You can also have charts that show how much work you're assuming is going to be done by partners versus associates versus paralegals. And this one, definitely, we get clients who say, why so many partners? Why do you really need 2 partners? Can't you push this work down to what are you doing to find the right lawyer at the right price? So you're showing all up front because I would much rather have that discussion before I send the bill. Then we have all sorts of additional charts which make my head spin sometimes. But this is a good one. This is kind of like a Gantt chart for those of you who are familiar with construction projects or project management. The colored lines represent the passage of time. You can see the time is down in the bottom. So case assessment's going to start in March of 13 and go all the way through the projected end of the case. But the pretrial pleadings, which are shown in red, have a start date of May and an end date of July. So you're showing the client, here's when we think we're going to be working on pretrial discovery. And then as you'll see in a minute, we can then overlay the actuals once we start sending bills and see how we're doing. So you can present the information in any number of ways. You can show the staffing allocation by hours or fees, whichever the client's more interested in. It's just a way of having transparency with the client. Here you can stack the phases on top of each other by category of lawyer, so the partner, all the information about your projected partner work is right there in the left-hand column. And clients can pore over these things and then can call you and have questions. Or they can say, wow, this firm really spent a lot of time thinking about this, gives me a lot more comfort that it actually has some validity. I'll feel better reporting to my business people about these numbers. Okay, so you finish your budget, but you don't put it on a shelf because litigation budgeting is not done when you create a budget at the beginning of the case. The most important part actually is where the rubber hits the road, as the case is going and you're sending bills or receiving bills, what is actually happening in the case compared to your budget. Don't let your budget, grow moss under it. So we have a series of budget versus actual reports now. You'll recognize the framework. we'll have the same budget reports, and then we add in black lines which show the actuals. So like on this chart, the black line will show you time, focusing on the top line there. Case assessment, there's the $216,000 number we saw before, and there's the blue time period from April to October. The black line under it is a report of how we're actually doing. When did we start? Are we still billing today on this phase? And how much money are we spending? So in this one, you can see both time and dollars in one easy place. Here's another fancier way to do it, where we've added in the gray part. So the blue colors you'll recognize, which are color-coded by ABA phase. The black shows actual. And then the gray line is the lawyer's judgment as to what % complete we are with that phase as of today. So let's say we're 3/4 of the way to trial, but we may conclude we're only 50% done with discovery. So the lawyer reflects that by answering questions that show where the gray line is to go. So you can show the client, yeah, we're under budget in an absolute sense, but I'm foreshadowing trouble because we're only 50% of the way there in terms of doing the discovery that we projected we were going to do, and it's costing more than we thought, so let's have a discussion about that. This is just a blow-up that shows you how the actual can sometimes be less than what you budget, and down at the bottom, the actual went over, and we're already, have spent more than we budgeted for the document analyst phase of this case. Again, you can show the actuals, what you budgeted for staffing allocation versus what you're actually receiving, actually performing. And here, just another way to present the same information by granular phase. How many hours have we spent? How many did we budget? How many hours have been consumed? What percentage of those hours have been consumed? And then the lawyer's estimate of the milestone completion. Just different ways to show the information and share it with the client. In conclusion, my whole theme is that we should all embrace litigation budgeting. It's here to stay. The people who embrace it first are going to be out front. It's a way to help meet those two goals, delivering more value and controlling legal costs. Thank you.